Hi, everyone. Thank you for joining us today for Constangy's webinar, DEI and the Aftermath of the SCOTUS Affirmative Action Decision, What's an Employer to Do? A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. Our presenter will leave time to answer your questions. This program is pending SHRM and HRCI credit. We will be sharing those codes at the end of this presentation, so please stick around in order to get the codes. Lastly, we will be providing a copy of the PowerPoint used during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow morning. I'm now going to turn it over to today's presenter, Cara.
Thank you so much, Victoria. I see people are still filing in, so we'll give it a few minutes to let people make sure they can join. All right. I'll just reiterate what Victoria said about the presentation materials. We will be providing a link to the recording. And so make sure you do know that it is being recorded. And we will also provide a copy of the PowerPoint slides as well. Since we have fairly limited amount of time, the 60 minutes, there may be some slides that I cover very quickly or even skip over just because there is a lot of material. So we want to make sure you have the whole presentation afterwards so that you have those materials as well. I think that's it from the housekeeping standpoint. It looks like the joining is starting to slow down a little bit, and I have 2 minutes after officially, so let's go ahead and get started. Thank you so much for joining us today, and thank you to Victoria for the introduction. Want to wish everyone a good afternoon or good morning if you're joining us from the West Coast. My name is Cara Crotty, and I am chair of Constangy's Affirmative Action OFCCP Compliance Practice Group, and I spend a significant amount of my time advising federal contractors of their affirmative action legal obligations and employers in general about their diversity, equity, and inclusion practices. So I'm really excited to present to you today about the latest developments on diversity, equity, and inclusion since the Supreme Court's decision in June. I am going to, at this point, turn the video off. I think it can be a little distracting and you'd rather look at the slides than me anyway. And I have a tendency to talk with my hands, so I don't want to be distracting. So we'll turn that off and just go with the slides for now. Also, in case anyone is not familiar with Constangy, we are a national labor and employment law firm. We have well over 200 lawyers from coast to coast, and we practice in all the typical labor and employment areas, as well as cybersecurity and data privacy. Just a couple of disclaimers before we get started. First of all, I'm not providing legal advice today. We're obviously going to be talking about a lot of legal concepts, but just want to make sure that you get specific legal counsel that's relevant to your specific issues in the DEI space. We're just providing some general information today. And one other point, DEI has become a political issue. And so we are going to be discussing how conservatives and liberals, and I'm using the air quotes, I'm gesticulating like I said I would do, but you can't see me. But we are going to be discussing how different political parties have been reacting to the Supreme Court's decision. So please don't interpret my comments as me endorsing one side or one view over another. I truly hope to present both sides in an objective way. So this is a nonpartisan arena for the day. All right, so let's obviously start with the Supreme Court decision. And I am not going to do a super deep dive on the court's decision itself, as that would take up the whole hour. But we do need to do a very basic overview. The Students for Fair Admissions challenged the process used by Harvard University and by the University of North Carolina in selecting their student bodies. And the main issue was whether it was permissible to use race as a factor in selecting students. both Harvard and UNC admitted that they used race as a factor, and they argued that this was lawful based on prior Supreme Court precedent that allowed for it for at least a limited purpose and for a limited period of time. Those cases go back to the Greta versus Bollinger, Fisher versus the University of Texas. So there was really no questions of fact. There were admissions that race was a part of the admissions practice. The Supreme Court held that activity violated the Equal Protection Clause of the 14th Amendment, as well as Title VI. So the 14th Amendment prohibits states from denying equal protection of the law, and that includes making distinctions based on race. So any action that is based on race would be subject to the strict scrutiny analysis, which means that the practice must further a compelling governmental interest and that the use of race must be narrowly tailored. And in these circumstances, the court found that the university's practices did not survive that strict scrutiny. And there were really three main aspects or points of that decision. The first was that the university's practices went too far. And the court found that because, and I like their terminology, they said the college admissions process is a zero-sum outcome. If you're providing a benefit to some applicants, but not to others, then you're necessarily advantaging some at the expense of others. So in all circumstances here, they were penalizing individuals because of their race. So it went too far. The second part of the decision or basis of the decision was that the practices stereotype people. The court said when a university admits students on the basis of race, they're engaging in offensive and demeaning assumptions that people of a particular race all think alike. And they said that would violate the Equal Protection Clause. And then the third element of that decision was that the practices didn't have an expiration date. I mentioned the Fisher case, the Bollinger case, those date back to 2003. And at that point, the court said that race-based admission programs for students were lawful in certain circumstances, but that they must someday come to an end, and that permanent racial preferences would not be permissible under the Constitution. And they specifically said, we expect in 25 years from now that racial preferences would no longer be necessary. So fast forward almost 25 years, at least 2 decades, and both Harvard and UNC said that there was no end in sight to their race-conscious admission programs. So without any kind of meaningful endpoint, the court said that process was unconstitutional. And Chief Justice Roberts wrote the decision for the court, and I think that second to the last bullet point here on the slide, I think that's the most quoted portion of the decision when he said eliminating racial discrimination means eliminating all of it. And then one of the last tidbits from the court in the decision was that universities were not prohibited from considering a student's discussion about race and how it impacted their life, so long as they tied it in some way to the quality of their character or some unique skill, ability, or trait. So how does that Supreme Court decision impact employers? That's for my practice group, for our firm, we focus on employment law. So that was really the significant or salient issue for us. How does it impact employers? Well, the two laws at issue were the 14th Amendment and Title VII. The 14th Amendment only applies to governmental employers, not private employers, but Title VI does apply to companies that receive federal financial assistance. So certainly any employers covered by those laws would either be prohibited from using race in making employment decisions, or they would need to make sure they could satisfy that strict scrutiny analysis. But employers were already prohibited from using race in making employment decisions. Both Title VII and the Executive Order 11246 that apply to federal contractors both already prohibit the use of race in making employment decisions. And I have noted there are some very rare situations where employers could. That's outside the scope of today's discussion. But generally speaking, this wasn't a new legal principle for employers. We're already prohibited from using race. And to clarify, we talk about federal contractors being affirmative action employers. And this decision did not have an impact on that aspect of their compliance obligations. Affirmative action for federal contractors is focused on their recruitment efforts and ensuring that they have diverse candidate pools, not about preferences or quotas or making employment decisions based on race. Again, the executive order prohibits that. So for employers that were not making race-conscious decisions or decisions based on other protected categories, the Supreme Court's decision likely didn't affect your practices. But what did change? Why are we even talking about this? Obviously, there's been a hullabaloo since the decision came out. But if the law didn't change, what did? And I think the answer to that is it's the perception. And here we have the pendulum swinging back the other way, as it often typically does. After George Floyd's murder in 2020, we saw an immediate and intense focus on DEI, and employers, for a wide variety of solid, legitimate reasons, needed to make certain that they were staying competitive and doing the right thing. And there was an intense, deliberate focus and shift to make sure that they weren't just giving lip service to DEI programs. It became an important policy objective for employers. And so I think the Supreme Court decision has just refocused the attention of employers, employees, and as you'll see, various interest groups. And I think one's opinion about DEI, as we're kind of looking through what's happened since the decision came out, I think one's opinion or view of DEI is based in large part on how you perceive or interpret it. If someone believes that DEI is about increasing diversity in a non-discriminatory manner, ensuring equitable treatment, and fostering an atmosphere of inclusion, then they don't see any red flags around DEI. However, if someone contends or assumes that DEI is about explicitly or implicitly using race or other protected characteristics to make employment-related decisions, then it's not surprising that they would find such practices objectionable. And I think this is where there is a lot of disconnect around DEI. I think the vast majority of employers do the former here and not the latter. Certainly in some cases, there are employers who might be using language around their DEI programs that's imprecise or mushy, and it might be interpreted in unintended ways. But I think the gist of DEI for most employers really has not revolved around using race or other protected characteristics in making employment decision. And probably everybody on this call understands this, but I wanted to do just it's probably appropriate to do a quick primer on DEI, diversity, equity, and inclusion. So that the diversity component represents the benefits of having diversity of race and gender, background, thought, a variety of things in your workplace. The equity aspect refers to ensuring that employees are treated fairly without regard to any protected characteristics. And then the inclusion element signifies a work environment where employees feel accepted and that they can be themselves at work and still feel that they belong. That's in a nutshell what DEI is. And there's nothing inherently unlawful about those concepts. So what happened after the Supreme Court decision? Did anyone else get whiplash as a result of the various reactions that happened? You'd see one response, and then you'd see another one that was the complete opposite. And it was hard to keep up with the various interpretations and commentary that occurred. So let's walk through some of them, give you a quick overview. On the same day as the Supreme Court's decision, the chair of the Equal Employment Opportunity Commission, Charlotte Burrows, issued a statement basically saying that this decision doesn't have any effect on employers. Your DEI programs are still lawful. Now, of course, that's not a statement by the commission. That's just this one commissioner's comment on it. But you have seen, or I have seen employers relying on that statement in defending their programs. I would note that the statement is rather vague, and I don't think it should be necessarily interpreted as a stamp of approval on any and all DEI programs. On the flip side of that, we saw EEOC Commissioner Andrea Lucas come out, and I wouldn't say that she opposed all DEI programs, but she seemed to take the position that some employers have pushed the envelope too far. She made statements along the lines of any kind of race conscious and equity focused policies are indefensible, and there are employers that are doing that. She said many employers in the past few years have tried to achieve equity instead of equal opportunity. And I don't want to belabor this point, but in my opinion, achieving equity is a good thing. That just means treating people fairly. It's aiming for equality that can pose problems because you can't treat everyone the same. You've got differences in compensation and benefits and positions and accommodations, and the list just goes on and on. But of course, it is true that we do want to provide equal opportunity to our applicants and employees. We've also seen requests for commissioners' charges. The American First Legal Organization, which is led by senior members of the former Trump administration, including the former senior advisor, chief of staff, acting attorney general, they have been pushing the EEOC to issue commissioners' charges against various organizations. Obviously, it's no question what side of the political aisle these folks are on, but they have found public statements and policies by varying organizations, and they refer them to the EEOC, suggesting that they're violating Title VII. For example, the AFL alleges that Mars Company intended to achieve equal gender balance across its leadership teams, to increase representation of racial minorities by 40%, which it called a quota. They also allege that Mars had a leadership program and opportunities that were only open to women and people of certain races. Just a side note here on commissioners' charges. This is an additional weapon in the EEOC's arsenal. So in addition to investigating discrimination charges filed by individuals, Congress has authorized the EEOC to investigate possible discrimination using commissioner charges. So the individual commissioners can actually issue charges based on public information or information gathered during other investigations or other sources that they believe need to be investigated. And the charges aren't public, so we don't know whether the AFL's campaign to the EEOC has had any results. But I did find this interesting nugget on the EEOC's website. They do provide some general statistics on the issuance of commissioners' charges over the past couple of years. And you can see a pretty significant increase in fiscal year 2022. In my experience, there are generally very few that are issued. So I think the 29 total issued by the EEOC in fiscal year 2022 is pretty significant. And just for context, and for the government's purposes, fiscal year 2022 covers October 1, 2021 through September 30th, 2022. So that predates the Supreme Court's decision in late June of this year. So I definitely think it will be interesting to see what the results or the stats from fiscal year 2023 and 2024 look like. That might give us some insight into whether or not they did follow the AFL's lead there. So other letter writing campaigns. This is definitely the part that gave me whiplash. So just a couple weeks after the Supreme Court's decision, we saw 13 state attorneys general send a letter to the Fortune 100 CEOs. And these were states of the red persuasion, shall we say. And they basically said, look, we know you're discriminating against people and you need to stop doing it. They literally said racial discrimination is commonplace amongst your companies. And as the chief law enforcement officers of our states, we're going to enforce the law vigorously. That was obviously a few months ago. I am not aware of any state yet that has sued a company for race discrimination. Certainly, if anybody is, you can put it in the chat and I'll share it with the group later. But I'm not aware of any lawsuits actually having been filed. And then just a couple of days later, Senator Cotton of Arkansas sent a letter to 51 of the largest U.S. law firms, telling them you need to stop violating the law and discriminating against people, and you need to stop advising your clients in discriminating against people. And then, not to be outdone, 21 state attorneys general, this time of the blue variety, responded or sent their own letter to the Fortune 100 CEOs. And they basically said you should ignore the letter that you got from those other states. Your efforts to recruit diverse workforces and create inclusive work environments are legal, and they help you reduce your risk of claims for discrimination. They basically told them you need to double down on your DEI programs. So what's an employer to do, right, when you get these conflicting messages? And then a month or so after that, there was another letter from 5 state attorneys general to the AmLaw 100, top 100 size law firms in the country, warning them to stop violating the law by discriminating and using their DEI programs. And I attached this, the last item here on August 30th was a written opinion from the Kentucky Attorney General about their state's governor's minority management training program. The Attorney General there found that the program that they had in place was unlawful because participation in it was limited to minorities. State legislatures are also focusing on DEI practices, and I think that will only continue to increase after the Supreme Court's decision. It kind of began, I think, with the Florida Stop Woke Act. I'm sure many of you are familiar with that. This actually predated the Supreme Court's decision, and it was clearly modeled after and reminiscent of President Trump's executive order for contractors that prohibited training on divisive topics. Some of the language it seemed to be pulled from that executive order, which, by the way, was rescinded on day one of the Biden administration. But it's aimed at prohibiting employers from having mandatory training topics that teach people that they are, inherently superior or inferior to someone because of their race, or that they should feel guilt or privilege because of their race or gender, that type of thing. But significantly, a federal court has enjoined enforcement of this law on First Amendment grounds, so it's not in effect at the moment. We've seen states take aim at DEI, particularly at public institutions. Texas passed a law that terminates the DEI offices at their public universities. So it prohibits the use of DEI statements in their hiring practices, outlaws DEI training requirements, and prohibits compelling students or employees to endorse some kind of racial ideology. We are seeing other states that have passed or are considering similar DEI laws. This has all been happening fast and furiously. So these are the ones I was aware of about a month ago. It might even need to be updated since then, but you can see where the trend is heading. So, and what are we seeing in the courts? DEI lawsuits. We're seeing lawsuits by investors, and I call this the damned if you do, damned if you don't area, because we're seeing lawsuits from investors that are suing because companies aren't doing enough on the DEI front, and then we're seeing lawsuits by investors claiming that their DEI initiatives are too woke and are unlawful. Wells Fargo, for example, was sued by a pension fund for allegedly failing to properly implement a diversity search for highly paid employees, as they had promised to do. Danaher was sued by an investor alleging that the company breached its diversity goals because it didn't have a single Black board member. On the flip side, we saw a lawsuit against Starbucks alleging that its DEI practices were woke and unlawful, and that complaint was pretty quickly summarily dismissed by, I believe it was court in Washington. We are seeing significant jury verdicts in this area. You probably remember just a few months back this $25 million jury verdict for the Starbucks manager, white Starbucks manager, who alleged that she was unfairly punished and terminated after the very high-profile arrest of Black men at the Starbucks location in Philadelphia. She claims to have been made a scapegoat and suffered mental and emotional anguish as a result of that. The jury certainly sided with her in those arguments. Also recently, we saw a $10 million jury verdict in North Carolina by a white male executive alleging that he had been terminated by his organization and then replaced with a Black female. As part of as part of the evidence, he relied on the company's diversity and inclusion plan and a review of various demographic data as evidence of the company's discriminatory motive. That jury award was reduced to $4.6 million, and it's currently on appeal to the Fourth Circuit, so remains to be seen what ultimately will happen with that matter. These next few slides, and I'll probably move through them fairly quickly just out of an interest of time, but again, you'll be sent a PDF version of the slides. But we're seeing examples of lawsuits that where companies are being sued based on some aspect of a DEI program or alleged reverse discrimination. And I've included them here, not so much for purposes of showing what not to do, but rather for what we're seeing being filed in court. Most of these matters are still in the preliminary stages, and we only have the allegations from the complaint. And so with any complaint, whether there's validity to the allegations remains to be seen. But again, I thought these examples would provide some insight into what claims are being filed, what practices are being challenged. So there's this class action against Amex that has since been dismissed to arbitration, but the allegations were that the company had quotas for Black workers and that managers were required to reduce the number of white employees and allegedly received financial incentives for doing so. A recent class action against Gannett, alleging unfair treatment, preferential treatment for minority candidates in hiring and compensation. There's the allegation that managers were instructed not to hire any more straight white males. And then also an allegation that someone was told to rescind a job offer after failing to find a qualified minority candidate and was retaliated against after protesting that policy. We're going to talk about diverse slate policies in a little bit. And I don't think that it's necessarily unlawful. It's going to depend on what the practice is. But I think in general, having a practice to say, hey, we want to make sure we've done good recruitment and have a diverse pool of candidates. There's nothing necessarily unlawful in general with that type of practice. The lawsuit against Morgan Stanley. Again, this individual was terminated and claimed that he was replaced by a less experienced Black female to achieve diversity goals. And you can kind of see a theme that is evolving here. We're seeing a lot of these cases arise from an employee that's been separated. And they are alleging that their separation was based, at least in part, on the company's desire to achieve diversity goals. This case out of Texas was interesting, and I noted it because the district court's opinion denying the employer's motion for summary judgment opened with just some really language that was right on point, and I wrote it down, so I'm going to read it to you. The opinion opens with, "This lawsuit raises a question many companies are struggling to answer. What steps can a company take to encourage the promotion of women or underrepresented minorities without discriminating against men or individuals outside the protected class?" I mean, that just sums up this whole conundrum in a nutshell. But so the court looked at that question and then looked at the evidence that was presented and denied summary judgment to the employer. And in this case, the individual lost his position. It was a male employee, lost his position during a restructuring, applied for several openings, all of which were filled by women. And he pointed during the summary judgment briefing to a variety of diversity and inclusion efforts, including goals set for women, significant increase in the percentage of hiring for women, alleged direction from leadership, urging managers to leverage their transformation during the restructuring to accelerate their gender balancing goal, and so forth. And that case, by the way, appeared to have settled just a couple months after the denial of summary judgment. So law firms are not immune to this. You've probably heard recently about some challenges to law firms' training, scholarship, fellowship programs. And this is being spearheaded by the American Alliance for Equal Rights, which is an organization run by Steve Blum, who is behind the Students for Fair Admissions organization that challenged the Harvard's and UNC's practices. But they are alleging that law firms' fellowships dedicated to minorities is unlawful discrimination. The two lawsuits here, the Perkins Coie and Morrison Forster, those have since been dismissed after the firms changed their criteria for eligibility for their fellowship programs. Since then, though, they've gone after a couple other law firms. We just recently saw, it was either yesterday or late last week, a lawsuit against Winston & Strawn, who appeared to be ready to defend their program. They do use the terms disadvantaged and historically underrepresented as criteria for qualifying for their scholarship, or I'm not sure if it's a scholarship or fellowship program, but they have pushed back, and they said, you know, your understanding or belief that those terms necessarily refer to race is baseless. And I think that's, you know, potentially a good point if that's how it has worked in practice. Arguably, it, you know, I don't think you necessarily have to conclude that it would also exclude white men. You know, if we look at people's backgrounds and socioeconomic environments, that could, you know, potentially include those individuals as well. But in the lawsuit that was just recently filed, the plaintiffs are two straight white males who claim that they are being excluded. And then this lawsuit against Meta is interesting as well. This is Also brought by that American First Legal that we talked about earlier in the commissioner's charges slide. This lawsuit focuses on an apprenticeship program that, see if I can explain it succinctly. It's basically for production companies, and they have this initiative, and it's called Double the Line. So for any single production budget, the signatories to this program agree that they will double a position and allocate and pay for the cost of an additional person on the production staff who is a person of color. So by taking this pledge and signing on to this diversity initiative, they're basically agreeing to have a position that's limited to minorities. And that's what's being challenged in those circumstances. We're also seeing opposition to questionable practices result in claims of discrimination. And again, we're only going by the complaints here. We don't know what the actual facts are, but I noticed, I saw this lawsuit against Compass Group, who was sued by a recruiter who raised challenges to their Operation Equity program. This program offered special training and mentorship to women and people of color, and this recruiter claims that she raised concerns about that type of practice violating their non-discrimination policies. And her supervisor allegedly said, well, this is the direction the world is going, so jump on the train or get run over. We'll see how that one plays out. Another important issue is pending at the Supreme Court that we should, it's pending. So next term, next year, hopefully we'll have an answer to the question of what is an adverse action within the meaning of Title VII. This Muldrow versus City of St. Louis cert has been granted. And the issue or the question for the court is whether or not the transfer of an employee is discriminatory where it does not cause any significant disadvantage to the employee. So you get moved to a different job, but no change in your compensation or benefits or anything that we would typically consider to be a term or condition of employment. Is that sufficient to constitute an adverse action? In the Davis versus Legal Services of Alabama, cert is pending in that case, and the question there is similar. It's whether or not a paid suspension could be an adverse action under Title VII and Section 1981. And the issue of what is an adverse action or what constitutes an adverse action is significant because to the extent it defines what is a term, condition, or privilege of employment, it could impact the areas in which employers can make race or gender conscious decisions. What is allowable if this isn't maybe an employment action within the meaning of the law? And I'm not going to read it to you, but here's some excerpts of Title VII that highlight, exactly what does it that Title VII prohibits as an unlawful employment practice. So in the interest of time, you'll have that for your leisure reading when the slides are sent out. All right, so let's switch gears to the practical considerations for employers that flow from the Supreme Court decision and in the current environment. So we're going to talk first about practices to maybe avoid, and I don't mean to say that these are per se unlawful. Many of these are not necessarily unlawful, but they could increase risk by creating evidence that could support a discriminatory motive. So the ones we're going to talk about here, I think, are practices that I would recommend you seek legal counsel if you have them or are considering them. And the first is setting aside a certain number of jobs for females or minorities, just like we talked about in that Meta case, where they have, they've created an additional position. And the intention is to help build a pipeline that has more diversity in it. So there's definitely the best of intentions, but if you are earmarking a position based on race or gender, it could certainly result in discrimination. So that's one area to be pretty cautious in. Another one is setting unattainable or unreasonable goals. We've seen a lot of public statements about companies and their diversity goals, and there's nothing necessarily wrong or problematic with that. But I think if an organization isn't very mindful about how to do it and their methodology, it could become problematic. You don't want to commit to attain a certain level of representation or a certain percentage increase by a certain date without doing the math. Is it even realistically, objectively obtainable if you're not going to be taking protected characteristics into account? So you need to look at what your general attrition is, what's your history of attrition, what's your expected attrition, how many new opportunities do you expect to have? There was a lawsuit several years ago where the allegation was that the only way the organization could have achieved the goal that had been publicized would have been through either some kind of crazy attrition rates, and this person had been separated, or intentional discrimination. So be very mindful of goals that are set and use data to determine what an appropriate representation objective should be. Tying compensation or bonuses to attainment of diversity metrics. Again, this is not per se unlawful, but you can easily see how that type of practice can be used as evidence in a reverse discrimination case and has been used in cases. Managers can be heavily motivated to hire a certain demographic if their income depends on a specific outcome. So this is just another area where I would tread cautiously. I mentioned diverse slate policies earlier. So diverse slate policies can vary. The one I'm referencing here is where race or gender is ultimately a factor for whether or not someone moves forward in the selection process. The EEOC has taken the position that it is discriminatory to screen or cull through recruits based on race or gender. And the Commission's compliance manual on race discrimination specifically says that race cannot be used as a screening criterion. Obviously, when the Civil Rights Act was passed, in that context, the goal and the intent was to prohibit employers from excluding minorities or women candidates. But we know, of course, that the principle of non-discrimination applies equally to all races and all genders. So again, in the 1960s, the main intent was to prohibit discrimination against minorities and against women, but we can't do the opposite and move people forward through the process just because they're a minority or just because they're a female. So, if an employer has a policy that says a hiring manager must consider at least one minority candidate, and the process moves forward and continues until one minority candidate is organically part of that pool, I think that's likely permissible. You're not using race or gender in making a decision. You're making sure that the hiring manager has had the opportunity to consider a wide variety of different types of candidates. And that's just me saying my opinion. However, I think there is a concern where an employer has a policy that says our hiring managers must consider X number of minorities. And then to satisfy that, the recruiter culls through the applicant pools and picks out minority candidates to provide them. In that situation, applicants are being advanced because of their race and at the expense of other candidates, which is what I think the Supreme Court was advising against in the Harvard and UNC cases. You also want to avoid only using diverse recruitment sources. It is fantastic and great to use diversity recruitment sources. We recommend you use historically Black colleges and universities and any other diverse recruitment sources. You just don't want to rely on them exclusively. Employers, especially federal contractors, and under their affirmative action obligations, have been required to seek out candidates through diverse recruiting sources, and that is still okay. It's highly recommended. We just, again, want to avoid relying only on those types of sources. And this recommendation comes from the EEOC and the OFCCP, who have historically taken the position that using only word of mouth recruitment through existing employees can be a discriminatory recruiting process because it tends to perpetuate the demographics of your existing workforce. So I think that same position or argument could be made with any type of recruitment process that tends to exclude people of a certain race or certain gender. In fact, we are seeing claims against employers that rely only on college recruiting for certain positions as being in violation of the Age Discrimination in Employment Act, and limiting opportunities for, or not where an employer is not engaging in recruitment efforts to attract individuals who are over 40. Limiting opportunities based on race or gender. I think the law firm cases provide examples on these issues. And I think this is an area where employers are more likely to be vulnerable because they're acting with, and they have acted with, the best of intentions. And there's been such a focus on creating and ensuring diverse pipelines through the organization. And you see one or two large companies that adopt an initiative, and then everyone just jumps on that bandwagon and thinks it's a fantastic idea, and they aren't necessarily stopping to think through all of the various legal implications that the Supreme Court decision and the resulting conversation has brought to light. And then last in this section, I wanted to include a reminder about supplier diversity programs. We are seeing lawsuits in this area now as well. It's not an employment issue, but these often go hand in hand. So just a reminder that Section 1981 does prohibit the use of race in making contracts. So we want to make sure that when we're selecting our suppliers, that we are not basing that decision solely on an organization or an entity's race or the makeup of their members. But I believe, just as we do for our applicant pools, it should be fine to make sure that we are creating a diverse pool of suppliers from which we are applying our non-discriminatory selection criteria. I don't think that's likely to pose any problems. Again, it goes back to the whole concept of affirmative action for federal contractors. The goal is to create a diverse pool of candidates to which you then apply your neutral, non-discriminatory selection processes, and then over time you will see the diversity of your workforce and here your suppliers increase. On to the positive side. What are some best practices on the DEI front? One of the first recommendations I have is that if you have a specific policy or practice and it uses the word minority or women, replace that with white or male and see how it sounds. If it makes you cringe, you might want to take another look at it. What I think is happening, certainly, as I mentioned with the Winston Strawn challenge, their argument is we're not focusing on race. We're talking about the underserved, the underrepresented, the underprivileged. And if you use terms like that don't exclude people based on race, but can still offer benefits to people from different backgrounds, maybe less affluent backgrounds that haven't had the same opportunities, then I think those are likely going to pass muster. And certainly you can take advantage and use the language from the Supreme Court's decision that talks about focusing on people's life experiences and their character rather than race or ethnicity. Placement goals, we talked about what not to do, but if you're going to set placement goals, and certainly federal contractors do that, there's nothing there's nothing per se unlawful about them. You just want to make sure that you're basing them on objective factors. You're not pulling a number out of the air that you think sounds good. Make sure that they're reasonably achievable. Typically, the expectation is that they will be achieved gradually and incrementally. You can't expect generally overnight success because it takes a while to move that needle. Again, depending on how many openings, what your attrition is, and so forth. And I also recommend that you measure your achievement by the percentage of placements. It's a more defensible way to set goals and to measure your progress because it's based on the number of placements and the percentage that are filled by the targeted group. For example, if 1 out of 10 openings is filled by a minority, that's 10%. And if you had a 10% goal, then you would have achieved it during that time period. Of course, that was just one placement, so it would not have changed your overall representation very much, but you have to take into account the number of opportunities that you do have when you're measuring progress. Make sure that your employment practices are neutral, and that we don't have any practice where race or gender is a factor in making an employment decision or providing a benefit of employment. You go back to that text of Title VII, it talks about the terms, conditions, and benefits of employment. It's a best practice to analyze your selection processes and practices to determine if there's any adverse impact that is occurring against or on the basis of race or gender. So this one's more about removing inadvertent barriers that you wouldn't otherwise know exist if you don't look behind the curtain, so to speak, to see what results your practices are having. And if you are using artificial intelligence in your selection process, it's definitely super important to analyze the effect it's having to see if it has any adverse impact on a protected characteristic. You want to make sure you're conducting a periodic review of your DEI policies and practices. Conducting an equity audit of your DEI programs is important to see if it's actually working. Is it doing what you would expect it to be? Is it not going far enough? Do you need to make some changes? And obviously, you also, as mentioned, want to make sure it is not having a discriminatory effect. And actually, here's a little plug. A colleague and I did a session earlier this year on conducting a DEI audit. Laura DeLeon and I did that. So if you missed it and want a link, just send me an email. My email information will be at the end of the session, and we'll be happy to get that to you. Victoria will let me know if we don't have it and I overcommitted, but I think we do.
We do have it.
Awesome, thank you. Make sure you're using a wide variety of recruitment sources, including those that focus on protected groups. You just want to make sure you're not stating a preference for certain race or gender in your advertisements. Job descriptions. These, I think, really present a good opportunity for employers. Make sure that you're updating them and reviewing them. Their jobs change all the time, and the minimum qualifications can change, or you might think they might become outdated. And when that happens, they can unnecessarily screen out qualified people. And the two areas that I have the most concern about oftentimes are the education requirements. Does someone really need to have a bachelor's degree or a master's degree for this position? Because those types of educational requirements will often screen out women and minorities. So if it's not necessary, and if you can replace that with experience, then you should consider including that in the job description. And physical requirements, those can have a tendency to screen out individuals with a disability. So make sure that they accurately reflect the requirements of the job. You want to try to use gender neutral terminology. I think that's those of you that use ChatGPT or other artificial intelligence. Those types of programs are good at writing, drafting job descriptions, and you can tell them how to do it in certain ways, but you obviously need to make sure a human reviews it and certainly is assessing it for all of your legal requirements. And I also think it's a great idea to advertise the organization's equal opportunity status and the importance of DEI to the organization in your job descriptions or job postings, so that potential applicants see that and see how important it is to the company. There are lots of surveys that show, especially with the younger generations, that is a significant factor when they are deciding what employer, where they want to go work. So candidate pools, ensuring that candidate pools are sufficiently diverse before you are applying your selection process. This is different than what we were talking about before. This is different than, different from passing applicants through the process because of their race or their gender. Here, what we're talking about is making sure that the demographics of the entire candidate pool for a specific position are reasonably in line with what you would expect them to be based on the availability data for that role. And I think it's permissible to continue recruiting until you get that critical mass. But we are not considering the race or gender of any specific candidate in this circumstance. And then once the pool meets that objective or reasonable diversity criteria, you move forward and apply your neutral, non-discriminatory selection process. I need to speed up. We're getting close to the end of our hour. Review and assess your selection process from beginning to the very end, from recruiting to offer. Make sure you have consistent policies and procedures. I recommend at least a high-level written policy to make sure that everyone involved in the process is doing it consistently. Utilizing diverse hiring panels. This has long been a suggestion of DEI expert, and it basically just means having multiple interviewers of different races and genders and backgrounds and so forth. But I wouldn't force this. And by that, I mean, I wouldn't require a diverse hiring panel in every situation if it would result in including decision makers that don't have a relevant experience for the position. So don't try to put a square peg in a round hole. Make sure we're training our managers and supervisors, use experienced professionals in the DEI space. Unconscious bias training is still generally okay. But we want to make sure managers are held accountable for following EEO policies, fostering an inclusive environment, and we need to train them on these topics so that they know how to do that. Keep a sharp eye on communications relating to DEI, our internal communications with our existing employees, our external communications to our potential employees, our customers, our clients, the general public. And make sure that the message that we are providing is consistent and accurate. And the same is true for our C-suite. What your CEO and other executives say can and will be used against you. We've seen alleged quotes in complaints around this topic, and so making sure they're educated about the proper way to phrase things is definitely an important aspect. If you have employee resource groups or affinity groups, make sure that they are open to all employees. We want to make sure that anyone can join them, even though their focus might be, a specific demographic. Certainly, we want to have rules of engagement to make sure everyone is respectful of others. And this might be an area, I shouldn't say might, this is an area where you want to consult your labor counsel because it can raise protected concerted activity issues as well. Take any internal complaints seriously. Don't assume just because someone is taking issue with a certain aspect of your DEI policy or program that they're overreacting. Take that kind of complaint just as seriously as you would any other, and hopefully avoid any type of retaliation issue by doing so. Stay up to date on legal trends. This continues to be a very rapidly developing area. As I mentioned, that Supreme Court decision coming out next year on adverse action could potentially have an effect as well. And just a couple more slides. We'll conclude here on me with my crystal ball on what might happen next. This is just me speculating a little bit, so you can take it with a grain of salt. But I didn't just pull these out of a hat. There is some basis for them. I think we might see rebranding of DEI, potentially less focus on the diversity and more focus on the equity, inclusion, and access. For those, I think there are a few friends here in South Carolina with me. You may have seen in the news just a few weeks ago that the University of South Carolina changed the name of its DEI office to the Division of Access, Civil Rights, and Community Engagement. I suspect that it was not the first organization to do that, and it won't be the last. Less transparency when it comes to DEI and employment practices. This is a survey or a study done by Bloomberg, where they looked at the mentions of DEI on earnings and at conferences among the Russell 3000 companies, and saw that it fell by 54% from a year ago into a low since 2018. I think we're seeing this happen with in the SEG area as well, given some of the pushback and concerns raised in that environment. And then finally, budget. This is more of a speculation, but potentially given this environment, I think some companies may consider devoting less resources to DEI. Many won't be affected, and many are going to devote more, I am sure. But I think there are going to be a few that might be hesitant to invest more, especially in this uncertain economy. So with that, and I know many of you are staying on for this most important slide, so I will show you the SHRM and HRCI numbers so you can make sure you get your credit. I do have a couple of chat questions here, I think. So while you guys are copying that, let me see if I can get the webinar chat here. So one question was, there any advice on how this impacts ERGs? I talked about that a little bit. I don't think there's going to be a huge change on ERGs. They're still lawful as long as you continue to implement them fairly and equitably and allow individuals from a variety of demographics to join them. There are the codes. Here's a good question. Okay, would you help us understand the difference between a placement goal that may include a percentage and a quota? And to answer that in a nutshell, a quota is we have to have X number, or we are going to hire an X number of people of a certain demographic, or we are going to fill 40% of our open positions with an X demographic. That's a quota. A placement goal is an objective. It's a target. Like, we're going to strive through our diversity recruitment to try to hit this number. It doesn't have to be attained. We're always going to hire the most qualified candidates. So you're not forcing it like you would have to meet a quota. A quota basically means, it's a mandatory number that must be met. So that's kind of a quick, simplistic distinction between a placement goal and a quota. I think the main difference is placement goals are aspirational, and there's no downfall or downside if you don't achieve them. For example, federal contractors have to set placement goals when their representation for females or minorities is less than what you would reasonably believe them to be based on the availability statistics. But they cannot get cited by the Department of Labor for not achieving that goal. The Department of Labor will look to see, what did you do to try to achieve it? What was your recruitment efforts towards the targeted group? And as long as they made reasonably good faith efforts, then they're in compliance with those regulations. Yes, we will be emailing the slides. I'll go back to my contact information should anyone need that. What are your thoughts on leadership development leadership development targeted for women? Should men be included? I think this is one of those areas that is receiving increased focus. I think the best practice would be to make it open for everyone. If you're excluding someone based on race or gender, I think that's what's most likely to end up being challenged. And it does, there are lots of nuances here. So I'm not trying to say there's a blanket necessarily, a blanket rule in every circumstance, because it's going to depend on, is it even covered by Title VII or Section 1981? But if it is, then I think offering a benefit to some on the basis of race or gender and not others could be problematic. So that's something to be mindful of. And what I've suggested to clients in the past that have looked at that type of program is to, I think it's okay to say, look, we want to help the women in our organization. These are the program opportunities that we have. But you just don't exclude people based on a protected characteristics. So that is my thoughts on that. So I think that's about all the questions. And we're 7 minutes over. So again, feel free to email me or reach out to me if there's anything else. I'm more than happy to help. Thank you so much for joining us today. And as Victoria said, the recording and the presentation will be out probably in a couple days. Thank you so much.